track and we're going to get started from the beginning, so I apologize for that. So good afternoon and welcome to today's webinar, Patent versus Publication and its Effect on Your Career. Thank you all again for attending this webinar, which is a part of a 5-year series hosted by the Center for Sustainable Materials Chemistry in partnership with the National Collegiate Inventors and Innovators Alliance. My name is Maisha Kumune Devonish and I will be your moderator. With me are Dr. Charles Williams and Mr. Paul Herman, our distinguished panelists who will provide us with a view of patents and publications in both academia and industry. Thank you both so much for joining us. When we think about publishing in science, we think from an academic perspective about the distribution of research and scholarship in peer-reviewed journals, which is more formally known as academic publishing. In the same regard, we associate patents with scientific industry where intellectual property is key. However, IP is also an important and integral part of academia, and as a subset of publishing, patents can be a part of the academic publishing web. Science progresses through a series of predictable steps that are generalized as the scientific method. At its core, there is an idea or hypothesis. Research is performed, observations are recorded, and based upon these observations, conclusions are made. These conclusions can be published, which is a format that dominates at the university level and is normally tied to academic promotion. These conclusions can also be patented to provide knowledge of the value of a discovery, and at some universities, these patents are used as part of the tenure review process. The patent route often leads to engineering, then production of a discovery, which can in turn lead to more research, and the cycle can continue on. An important part of this process is the interchange between patents and publications. In academia and industry, either or both options can be used, but this all depends on the desired path. If we look at patents and publications separately, we can see their relevance in academics and industry. In academia, there is the phrase publish or perish that exists. There is a push to publish as rapidly and as continuously as possible in order to garner attention and demonstrate academic talent. The recognition of talent can have mutualistic effect. If more attention is given to an institution, scholars can count on continued funding and steady promotion through their field. Even with non-institutional funding, the accolades still benefit the university. In industry, publications also have their value. Take, for example, the pharmaceutical industry. When we look at the dollars spent on R&D over a 15-year span, we see the purpose was primarily to formulate and produce innovative drugs. However, if we take a magnifying glass and look closer, we will find that significant portions of that spending was in support of publications in peer-reviewed journals. In fact, Merck spent 18% of R&D funds in this area. Why? There are several reasons. One is the competitive edge. Publishing scientific articles can help to position one company's innovation in the marketplace ahead of a rival company's similar innovation. There is also authority. Peer-reviewed publications provide a chance to demonstrate the legitimacy of an innovation, and they are also tools for swaying critical audiences. Another reason is explaining ideas. Companies get the opportunity to explain their innovation from a basic science standpoint, and as we all know, a well-written explanation can go a long way to answering many questions that will inevitably arise. There are many debates over the advantage or disadvantage of publications in industry, especially around the topic of IP. What is important to note is that publication as the primary means of providing information in academia does have a place in industry. Although we know publishing dominates at the collegiate level, patents are becoming an important slice of the academic publishing pie. This chart ranks the top 10 universities based upon the strength of their IP through quality and quantity in 2009 and 2010. There are a lot of numbers, and the metrics used don't provide a clear picture as to how this equates. So if we look at the top 10 universities based upon licensing income, we see not only new names, but also how much patents can mean financially to institutions. In industry, we are aware of how important patents are. Here are the top 10 companies based on number of patents issued. IBM has topped that list 20 years running, but even outside of the semiconductor and electronics industries, patents are critical where an R&D is involved. Close to 20% of all companies in the U.S. with R&D reported patent applications. A November 2012 issue of Chemical and Engineering News reported the efforts of government to commercialize research for economic growth. From academia to industry to government, patents play a role in economics. So what does this mean for you? Whether you are a graduate student or have recently graduated, how do publications and patents fit together into your career goals? In this webinar, our goal is to answer this as well as many other questions so that you can, 1, find out how industry and academia weigh the value of patents and publications in today's innovation-driven market, 2, understand how having publications and patents affects your future job prospects, and 3, learn about important factors to consider when deciding whether to publish or patent one research. So with that, let's meet our panelists. First, we have Dr. Charles Williams, Assistant Vice President for Innovation at the University of Oregon. Dr. Williams is responsible for overseeing the management of intellectual property, licensing UO innovations, and negotiating research contracts and grants. He received his PhD in botany and a JD from the University of Washington and the University of Washington School of Law, respectively. Next, we have Mr. Paul Harmon, Manager of Nanophotonics and Devices at Boxtel Incorporated. He has vast experience in innovation and management from his work at Boxtel, as well as his work at Hewlett-Packard. He received a master's degree from Stanford University in mechanical engineering, and he also received a bachelor's degree in mechanical engineering from the University of Washington. In addition to this, he holds 43 patents worldwide. As I mentioned before, my name is Maisha, and I'm a graduate student in the Center for Sustainable Materials Chemistry at the University of Oregon. I also serve as an editor for the CSMC website, and I am a member of the Center's Student Council for Innovation. The format for this webinar is as follows. I will ask each panelist 2 questions, and they will have close to 2 minutes to respond to each. After that, the webinar will be open to live questions from you, the audience, for about 45 minutes. You won't be able to ask your questions out loud, but under the question tab you can type them in, and I will gladly answer as many of them as I possibly can in the time allotted. Finally, I will ask each panelist to summarize his points and leave you with a take-home message. With that, I will start with a question for you, Dr. Williams. In recent years, there has been a push towards innovation at the university level that can have an effect on the hiring or tenure process. In general, what are the trends in patenting and publishing rates for new faculty?
Thanks, Maisha. It's been a great time to be at universities because there's been, I think, a renaissance in thinking about being impactful. So a lot of the new faculty that we've been seeing are extremely interested in seeing that their work actually gets into use. So they're not satisfied with just a journal publication. They really want to see that work get into the commercial stream and into public use for the public's benefit. So we're seeing an increased interest from faculty in a broader set of relationships. And that, of course, includes industry relationships as well. So something of a breakdown between thinking of just, oh, I'm a pure scientist or pure in a field versus applied or developmental. Thinking more about, hey, are there interesting questions that I might be able to provide solutions for? And there oftentimes are really interesting things that come out that just happen to be basic as a part of that. Another driver, I think, in terms of the trend toward looking at intellectual property more broadly is the need to diversify. So we're looking for many fields with flat federal funding, looking for partners that have increased dependence on our paying attention to intellectual property and putting an IP position in place. And then thirdly, many of the agencies now also are requiring PIs to have an IP plan, a sharing plan, or even a commercialization plan. So we're needing to think at the start of many of these projects, what do you think the roadmap looks like? What would we do with a particular set of work if it had inventive qualities, if there was intellectual property and a patent that we could apply for that might help that work get out? So it's very interesting. And on top of that, universities are increasingly engaged in an economic development mission. So we provide, in many of our regions, much of the innovative fuel that's going to go into the startups that we hope will bring us out of the recession in the economy, as well as existing technologies that will be useful to companies that we are partnering with. So overall, I see quite an interest in intellectual property and quite an interest in thinking about patenting when it makes sense.
All right, thank you very much. The next question is for you, Mr. Harmon. In industry, the percentage of patents to publications is not 50-50. So overall, are patents and publications weighed differently for early career applicants in industry? Mr. Harmon?
Sorry, I was on mute. So thanks for the question, Maisha.
You're welcome.
Patents are different from publications. That may not be obvious until people have thought about it for a bit. Peer-reviewed publications do demonstrate good technical importance. Any of the peer-reviewed periodicals or web databases show that if an individual has created something that stands up well to peer review and gets published in those areas, it shows that they've done something new and innovative and contributes to the overall knowledge of science and technology. But not everything in those that adds to scientific and technical knowledge adds economic value. And generally, patents are taken out to protect economic value. And if someone has spent the money and gone through the legal process to put a patent in place, it's a pretty clear statement that someone thinks that the idea has economic value. And since companies are keenly interested in revenue and profit, you'll generally find that patents really pique their interest on a resume or in an interview. And they are a little more rare among people coming out of universities. You don't see people with patents as often as you see with publications. And so that's another reason why they stand out. But this, the ability to show that your ideas can generate economic value is always important to companies who are looking to hire employees.
Great. Thank you very much. Another question for you, Dr. Williams. Traditional views of research don't necessarily focus on commercialization. One of the questions that we have is, why are these views changing?
That's a great question. I think it's changed because we've realized that in many fields that we need to be more closely connected to the actual users of information, as well as the products and services that are germinated and sometimes go quite a bit down the road from the university side. So it's a good thing, I think, that we look at it in a broader way. And I think there's less of a concern that somehow one activity will taint another. And so what you can see in a number of universities is they've actually taken a step to include commercialization activities or activities that result in the generation of intellectual property and participation in technology transfer as part of their tenure review process, and in some cases part of the post-tenure review process. And in that, those institutions are saying, well, when you look at the three cornerstones of university excellence, that's teaching, research, and service. And you can think of some elements of research as being that commercialization component. You could also think of service being in that way. So if you look at Texas A&M, they've really created an additional factor to add into their system. If you look at, say, Oregon State University, where they've added patents or cultivars, kind of the agricultural sense, as well as disclosures, options, and licenses in as creative activity. So those are really evidences of creative scholarship. So trying to look more broadly at what is the impact of your work and who are the actual users, and not just that narrow slice of individuals in your academic field that might be reading the peer-reviewed journal.
Okay, thank you very much. And the next question for you, Mr. Harmon. In industry, what kind of questions could applicants expect to be asked about the patents on their resumes?
Okay, Maisha, there are really three basic questions, and I'll talk about them in sequence. One is how the technology works. Another is what does the interviewee see as the value of the patent to the marketplace. And then the third is how the team developed the patent or the technology that's in the patent. So for the first point about how the technology works, it's fairly common to find that a group of people have done a patent. It's a little unusual to have a patent done by a single individual, although it does happen. And but either way, the company is going to want to be confident that someone with a patent on their resume has actually contributed to the patent and understands the patent. And so the individual is going to have to be able to discuss intelligently what goes into what went into creating that patent, you know, the background, the research, but also how the patented technology works in some detail, because likely they'll be talking to somebody who is from the same field they're in and understands the patent, or at least thinks that he or she understands the patent, and will be probing for whether the interviewee actually also understands the patent. So in the second area, the the value to the marketplace. Now this one is a softer question, because usually people with patents are applying for technical positions, and they're not applying for marketing positions. But still, the company likes to see if an individual they're bringing on board can connect technical value or technical capability with market value. And as I mentioned earlier, somebody thought that there was market value to this patent, or they wouldn't have bothered putting a patent in place. And it's always interesting to the company if business and technology can be connected in the minds of their employees, especially people that are applying for engineering and scientist positions. So some idea of what the market value is a good thing to come prepared to an interview with, although it's a little fuzzier again, and it's not as precise a question as the first one, which is how the technology works. And then the third area is kind of a bonus question, but it's usually important to companies, because unlike a lot of academic life, the corporate life is involved with making teams work. It's very unusual in a corporation to have a totally lone wolf sort of job. It does happen sometimes, but usually 90% of the time, people are working in groups. And the interviewer will probably ask how the technology was developed in the group, how this particular interviewee participated, and who the other people were on the team, and how they interacted, and how they structured their work so that the full technology was developed and patented. So I think that's probably the three basic areas that you could expect to be questioned on in an interview.
Okay, great. Thank you very much. So now with that, what we'll do is we'll open up the webinar to live question and answer with the audience. And right here, right now, I have one interesting question, and I think that this would be a very good one just to speak about generally. I will ask this to you, Dr. Williams, and I think that maybe in this regard, maybe a general idea about the process of patenting along with publications would be ideal. The question is, are there ways to publish data or ideas before we get a patent, or must we patent first, then publish?
Sure, that's a great question. If you want to have a patent portfolio that's international, then you really actually do need to get your patent application in before you make the public presentations or publish. If you're only looking at the U.S. market, then there is what's called the grace period, which is a year for which you can still apply. Now, the patent law in the U.S. is changing here very shortly, under a month, and the grace period will not be quite as beneficial to universities and our inventors as it has been. There are some twists to it that I can't really go into in this conference, but you'll want to think about that as a researcher as that law changes. But the idea is not to engage your tech transfer office at the point where everything has already been done. Really, you want to be talking with us as your project is unfolding, as you're thinking about how some of that inventive work that you're doing could potentially be in a patent application. And then we're in a better position to put everything together and file very promptly on your work. We also have the ability to file what's called a provisional patent application, and that buys you time, but you still need to be able to describe fully that invention in your provisional application, and that you may not actually write out the claims or the legal bounds specifically, but you're going to need to get everything in there that you think you can claim, and that takes some conversation with the patent attorney and your tech transfer manager as well. So really, I'm not thinking of this as a process where you invent and then engage the people that can help you. Think about doing that as part of your project over the long haul.
Okay, thank you very much. Yeah, we're getting some really great questions in here. Thank you, audience, for asking them. This question, I believe, is actually going to go to the both of you. So it's a two-parter. And so first I'll start off with you, Dr. Williams. If I invent something at a university, how is the intellectual property parsed out? And then the second part of that question is for you, Mr. Harmon. How would that be different in a company such as Voxtel?
So if you are an inventor within a university, you would go look to the IP policy that each university, or at least major university, has, and that then governs what your relationship is with the institution and how ownership falls out. Generally, most universities will acquire ownership in your inventions that are produced under externally sponsored awards or with significant use of institutional facilities or resources. So that's as a general rule. And then if you're in a different country, you may have different elements to consider. The federal government has regulations called Bayh-Dole, which for many of our scientists, those apply to the university and to all the researchers that are working under those awards, and those have details you can read about. But the basics are they allow the university to acquire ownership in the inventions created under those awards. If you're working with code or software, so we're getting off the patent track, then there may be some more complexities to that, depending on your university's intellectual property policy. The one thing you really do want to think about is making sure that you're aggregating all the intellectual property related to this really fabulous innovation together. So yeah, that means, as Paul was saying, it's very rare to have a lone wolf. You oftentimes have multiple inventors, multiple people that have contributed to copyright code. The university, a lot of what we do is actually get everybody together, aggregate those, create the provenance so that someone will invest in that, which means we make sure that the rights are all documented very carefully. We make an investment then as an institution in acquiring rights in those patents, which are in the tens of thousands of dollars, so most researchers aren't in the position to make that financial bet. And then lastly, you actually share in any of the licensing revenue that we manage to produce if we find a licensee or a startup company goes out. And roughly, most universities in the U.S. are about a third that goes to the pool of inventors, about a third goes to the academic unit associated with your work, and then about a third goes back centrally to cover the costs of things. And that varies a little bit between universities, but that gives you a basic idea.
Okay. So in a company such as Voxtel, it's going to be different. Companies, again, are for-profit institutions, and one of the reasons they hire technical employees is to generate intellectual property in the form of patents, usually, sometimes trade secrets, though, that they can use to create products and defend those products in the marketplace from people who want to copy those products. So the bottom line is, for most companies, there's an employee agreement that you sign when you join, and you agree to turn over intellectual property developed while you're an employee to the corporation. Now, the patent is still in your name, but it's assigned to the company that you work for. Some companies, such as Voxtel, actually it's fairly common practice, but not all companies do this, but some companies do give bonuses and incentives in pay to the employees, and some of those can be quite substantial, and in the thousands of dollars for putting in patents. And there are some companies, and these are much fewer, that will decide, have a formula for deciding a percentage of revenue in the company that's based on particular patents, and distribute percentage type bonuses to employees. That's fairly uncommon, but it does happen, especially in companies where they're really driven heavily by their IP.
Thank you. Actually, as a follow-up to that, Mr. Harmon, one of the questions that we have is, in industry, who decides whether to publish or patent a particular research outcome? Is it the inventor, the company, investors? Who really is the main player in deciding when patenting or publishing is going to happen?
Well, again, in a company, it's normally a team activity. The inventors obviously come up with the technology that they think has value. Management of the company will determine, in the end, how the intellectual property fits with the company's strategy, and then based on that, they'll usually decide whether to publish or patent or to keep as a trade secret. So if you're a company that makes, say, medical instruments, and one of your employees comes up with something that moves the medical instrument technology along and really adds value, immediate value to your company's patent portfolio, you're going to want to patent that, and then you may decide to publish it at industry trade shows or at consumer events as a way of demonstrating the technical prowess of your company. And normally, when that's published, the inventors are involved in that publication and those presentations and that kind of thing. Sometimes somebody may come up with a really great idea, but the company's decided they're going to go in a different direction. Very often they will decide not to patent that, but they will allow the inventor to publish it, and maybe send him to a trade show to hold a panel discussion or a seminar or something. It's also fairly common that there'll be a process patent or something that's fairly difficult to defend in the marketplace, even if you have a patent on it, and so the company will decide to keep it a trade secret. And that means that it's in the best economic interest of the company not to let anybody else know that it exists. And that kind of intellectual property protection also is fairly common.
Great, thank you. All right, I have another question out here. So many good questions are coming in. Thank you all so very much. Here we go. Is it better to layer your patents? For example, release parts of the technology sequentially or as you publish concurrently? Or is it better to patent everything at once? And I'll start off by asking you this question, Dr. Williams.
Generally, if you can layer, that's a nice strategy. One of the difficulties in applying for everything at once is the sheer cost. So universities typically don't have the same types of patenting budgets as a large corporation might. So we do have to be really strategic in how we lay that out, and by layering and thinking about how those patents may actually run across the real products and services you might produce. That's a higher value generally. I'll let Paul talk more because he knows more about that space than me. But you really want to think strategically, and there are instances where it may be good to throw everything in at once and try to see what you get to issue really quick because you need to show the market investors what's going on. But you need to think carefully about that.
Yeah, I would add to that that there's a rule that I learned over the years in patents, and that is you want to keep your patent as basic as you can get away with. So let me give you an example. And I spent a lot of time with inkjet printing, so I'm gonna draw from that background. If I was to design a new ink for an inkjet printer and I had changed the level of the dye in the ink and it made the black more black so that it looked better, the first thing that a good patent attorney will look for is how basic of a patent can I make out of this? Could I patent the concept of black ink completely, right? Now, probably can't be done. Previous printers have had black ink. There's been other patents, etc. But you start at that level, and you always try to get the most basic idea patented so that you have the broadest coverage possible. The other extreme of that would be to say that I developed this improved black ink for a 64 nozzle Hewlett-Packard DeskJet 101P printer, right? that makes a very, very narrow patent because it only applies to that particular model with that number of nozzles in, this company. And it allows somebody to come up with a printer that has 62 nozzles and use your ink and get around your patent. And that brings up the main reason why I agree with Mr. Williams about the idea of layering, because you want to avoid as much as you possibly can connecting in your claims or in your technology descriptions the different threads of your patent of your machine, because the more interdependencies you have, the easier it is to get around a patent and for somebody else to take the economic value that you generated. So it takes some time to think that through usually, and a lot of the art of generating a good patent or a good set of patents is in getting as much coverage as you can for your idea so that others can't come along and essentially get around your patent without doing the work that you put into it.
Okay, thank you very much.
If I could just pipe in, one of the things that's really sometimes hard for researchers is to think in that a patenting register, which is very different than what you would do for a peer-reviewed publication. You really are being very expansive, as Paul was saying, and that's something that sometimes is hard for folks to kind of change that element of their thinking.
Okay, yep, that makes a lot of sense, being a publisher and all from this perspective. This is also another question for the two of you, and I'll actually start off with you in this case, Dr. Williams. You had mentioned that patent laws are changing soon, so do you have any insight into how the key changes will influence academics and how they approach intellectual property?
Sure. I think that when we actually decide to publish, that we must be more careful in terms of how completely we publish on a particular innovation. So with the new grace period and some of the follow-on laws, we're going to need to make sure that if you do put your stuff out there that you're very complete, that you don't allow for someone else to. We're changing, for those that haven't followed, we're changing from a first-to-invent system to a first-to-file system, which is what primarily the rest of the world has been under for some time. And in doing that, there are going to be different priority issues, and people oftentimes across the world are, working in the very same creative space, and they're coming up with innovations that are very similar, if not the same. And so some of that is a little bit of a race to the patent office if you're in a field that there's a lot of competition. But also, if you decide that you're going to publish and not pursue the patent, then you want, or if you want to take advantage of the grace period in the U.S., then you're going to want to make sure that you actually put your publication out there complete, or someone else may either bar you by publishing some other elements from getting that patent during the grace period, or you may actually find yourself cut off by some narrower patent, as Paul was describing, that only captures a piece of it. But now you're in a situation where you're kind of locked up. So there are a lot of intricacies. I don't know that major university patenting practice is going to change, but it really comes down to having a very proactive practice, and for the researchers at the Tech Transfer Office to be working as early as possible. You want to be strategic and be planning. You don't want to be at the last minute coming in and saying, hey, I've got a publication tomorrow. There's just not very many good decisions are going to be made in that kind of environment.
Okay. And Mr. Harmon, how about from the industrial perspective?
I think that, again, the bias in industry is to ferret out the economic value and patent it rather than publishing information. And a lot of what Dr. Williams just said holds for industry as well. You really want to make sure that you're able to get as much of a broad application of your idea as possible.
Okay, great. Thank you. Actually, this is another question for the both of you. I like this, that you both can answer this from different sides. And I'll start with you, actually, this time, Mr. Harmon.
Okay.
How difficult is it to patent a process as opposed to a thing? And so I think the example here is I'd like to use, for example, I'd like to use an existing chemical synthesis, and it has been published in several places for a novel application.
Okay, thanks. That's actually a real good question, and Voxtel wrestles with that fairly often. There's a basic rule that you tend to apply when you're looking at whether to keep a process a trade secret or to publish it. A couple basic rules maybe. The first one is, are you in a business where the process dominates what you're doing? So let me give you an example. If you're making you know, 1 million iPhones a month, the process of making those iPhones is going to be fairly hidden from the world and difficult to inspect and capture, just because there's so much activity going on. You know, Samsung and Apple and HTC may all have similar processes, but they're scattered around the world in subsidiary factories and other things, and it's very difficult in those cases to really make a process patent that holds its value. The opposite extreme, though, is if you're in the business of supplying, you know, I'm trying to think of something. Oh, I know an example. If you're in the business of supplying a ion implant device for wafers, now that's a very narrow market. There's only 3 or 4 players. The factories where those ion implant devices are made are, you know, known, and there's like 2 or 3 of them, and the process of actually creating those devices is very, very difficult, and you know, it's something that dominates the value of the device. So in those cases, it's the process patent has more value because there are a lot fewer players, and it's much easier to catch somebody if they're actually violating a process patent. The third way in which a process patent, the third factor you want to take into account in thinking about patenting a process is, can you see the results of that process uniquely in the device that you make? In other words, can you look at the device with a microscope or by tearing it apart or whatever? You know, with chemical processes, which the question was based around, can you look at a chemical signature in the output of the process and say that only this process could have created that chemical signature? And if that's the case, and there are cases like that, there are sometimes you use a radiation for a step in a process, and it has a unique radiation signature depending on how you did it. So if you can find a unique signal from your process, then you definitely want to capture that, because that gives you protection in terms of people have to find a way to make the product without that signature showing up, and that signature can be crucial to the functioning of the material or the device. So with those 3 factors in mind, you can kind of decide whether or not you want to patent your process or keep it a trade secret.
Okay. And for you, Dr. Williams, from the academic side of things, how difficult is it to patent a process as opposed to a thing? Or do many people, when they do want to go through the tech transfer process, do they come up with a sort of difference between the two and try and do either one?
So, you know, actually, you know, obtaining and writing out a patent is the same. There's no difference really. The tricky part for the universities are twofold. You know, one is we're not the best place to keep secrets, so we don't generally deal in trade secrets. We publish, and we have to be very cognizant of the research exemption that the federal government gives us to a lot of the export issues, because we are an open environment. So there are universities that have, you know, split personalities in different parts that do different things, and some of them have more secret areas. But in general, most universities are going to publish. The second issue that you have to think about is universities generally themselves are not going to go out and sue under the patents that they acquire. It does happen, and there are some big cases out there, but we are generally not equipped, and we're trying to actually create you know, many relationships, not actually go down the litigation side. So when we look at what might be a process patent application, the real question goes back to the factors that Paul enumerated, and that's if we have an industry partner, are they going to pick that up, and then do they find that it has utility in terms of their economic value? So, we would not likely patent a process just speculatively. We would want to know we have an industry partner, or there's some other way that that's going to get out, and they can then use it in a way that they see makes the most sense. If you're looking, one of the interesting things about a lot of projects, though, is that as you're looking at the overall innovation, you may find that there's some different ways that you can apply for a patent that's a system or some other element. So you take a look at what you can achieve, but if it's only a process, then from the university side, there's probably not a lot of patent activity going on.
Okay, thank you very much. I have there's a really good question that came in. Can you contrast the review processes and mechanisms for patents and publications? And that question is directed to you, Dr. Williams.
Boy, it's been so long since I've actually published. No, I think extremely different processes, and they're going to vary depending on your university. So some universities actually have a committee of faculty that goes through and reviews the disclosures and patentability, and then makes recommendations to the tech transfer office. Some tech transfer offices actually have external consultants in particular fields, and they'll farm some of those out for review in return. Others, like the University of Oregon, we've got 2 patent agents actually in-house right now, and we've got our managers are PhDs in their field, so they work through in partnership with the researchers what the patentability looks like, and in particular whether there's a economic driver for using a patent as a tool. So it can vary quite a bit, and it's not a the review panels are really directed at this economic issue and not at the merit of the science. So that's a fundamental difference.
Okay, thank you. I actually wanted to ask you the same question, Mr. Harmon, but actually there's another question that I really want to direct towards you. So we know that patents, it's a lot of money to file, a lot of money to maintain the rights, but they're very, very important in industry, and they're utilized quite frequently in industry. And the amount to file, the amount to maintain is a lot different than it is for journal publications. So from the industrial perspective, how do they evaluate the value of filing a patent as opposed to publication?
So that is the multi-billion-dollar question, because you can find examples in where errors have been made on both sides of that, where somebody published something that they thought was fairly innocuous and kind of interesting but not really all that valuable, and then somebody else had an application for it that they went off and made a lot of money on. And then on the other hand, you can find patents that great effort was put into creating and the company was very proud of, and yet no economic value was ever made of that. For example, of the first case, at Hewlett-Packard, we in the HP labs developed a LED, first it was a laser-based and eventually made it with LED-based motion sensor that could look at a surface and determine how you were moving across that surface independently of any mechanical connection to the surface. And this was done back in the 80s, and it was thought of as a really neat motion sensor, and they brought it to us as we were developing printers and wondered if we wanted to sense how our paper was moving because it was very accurate non-contact. And we looked at it, but we honestly didn't need that level of accuracy, and they looked at a couple other applications, and we really just couldn't come up with anything, and so it eventually, I'm not sure exactly what the mechanism was, but eventually it exited HP's control, and then people started making optical mice. And of course now everybody uses optical mice instead of mice based on balls, right? Now you don't ever see anybody with a little mechanical mouse anymore. And so that was a case where there was really quite a bit of value in that patent, but it wasn't recognized. And the other flip side is manifold. I mean, there are a lot of cases where people have put a lot of effort. The IBM Millipede comes to mind. It was a mass storage technology that IBM put hundreds of millions of dollars into developing and heavily patented, and I don't think they ever generated any revenue from it. So that's a couple of examples, but the bottom line is it requires insight and sort of a corporate understanding of how to connect market needs with technology capabilities. And that is the single most difficult problem in any technology-based enterprise, is really recognizing how you can connect an emerging capability with somebody's need for it. Because the key problem is usually people are not asking for it because they don't know that they want it yet. So nobody was asking for an optical mouse because everybody was happy with their mechanical mice, right?
Yeah.
Nobody asked for a laser printer because everybody was happy with their dot matrix fan fold feed impact printers. They didn't realize how cool laser printers could be. So nobody wanted a GUI interface because they were, well, maybe they weren't happy with DOS, but it's all they could grasp, right? And so over and over again, you find that people are surprised and delighted by a new technology that emerges, and sometimes the technology emerges without IP protection, and then the inventor doesn't really generate much value from that. And sometimes, of course, like an inkjet, for instance, it did emerge with Hewlett-Packard did a very good job of establishing an IP portfolio around that, and HP was able to derive a lot of financial benefit from that invention. So that's kind of I'm not actually answering the question because I guess I'm trying to tell you that it's a difficult thing to get right, and it requires judgment and insight, and sometimes in industry we get it right, and sometimes we blow it.
Well, thank you. I appreciated that answer. That was very interesting. And actually, as a tie-in, Dr. Williams, so patents are expensive to file, to keep. So will universities support graduate students' efforts to apply for patents, even though it can be costly?
Oh, sure. There's no class distinction in terms of looking at innovators in the campus. The IP policy applies to you whether you are in IT administration, a grad student, postdoc, or a faculty member. In fact, some of our most successful projects have been out of administration in terms of revenue generation. So we look at everything de novo. It's really a question of, is there passion? Is there a connectivity to the markets, particularly if there's industry interest? And it's hard to get things right. One of the major U.S. universities annually writes down $1 million in patents a year. I mean, there are large numbers of patent portfolios that just have not been moved. So it's an interesting problem, even for the universities who are not really working at the same scale as industry in terms of patent prosecution. But no, we really look at back to the criteria that Paul was describing. Hey, are you working as a team? Do you have a group of researchers that are really keen working in the space? Does it have potential? If it's something that everybody's going to drop the next day, that's probably not going to be something that's going to get out into the market, because there just isn't the follow-through and that technical acumen that needs to come along with oftentimes the IP rights that go along. I've rarely seen a patent piece of paper itself that has launched anything. It's usually a combination of the IP rights that you put in and then some wonderfully talented technical people. It's all a package. So we love to see grad students come in, and oftentimes even undergrads as well.
Great, thank you so much. I have another question here that, yeah, actually I can ask to both of you. So from this perspective, Mr. Harmon, do you think that the pressure to patent first slows down technological process? Because, if you're an individual who is going through this process, you're usually not able to discuss because of IP reasons. Do you think that's slowing down how technology progresses?
Inevitably, it slows down technology to some degree. So, and if you are an inventor and you're working away, your nose is rubbed in it all the time, because perhaps you'd like to contact some colleague that you have read about or know personally, maybe from a trade show or from going to school with them or whatever, at another company or at a university where they have some bit of knowledge that would help you in solving the problem that's in front of you. And so the IP boundaries make that difficult, and you are frustrated by that. Another way in which that's a problem is just the sheer time it takes to do patents. This is a minor tip for people. If you're in a team, it's an honor to be the first name on the patent, but it also means you do all the work. So that the patent lawyers can be quite time-consuming at some stages of the patent development process. And if you're the first name on the patent, you will be the one that they call, and you'll probably be doing most of the scrambling around trying to get all the ducks in a row for the patent. So yes, it can slow it down. However, if you take a bigger picture view of it for the company, it actually speeds things along. And you say, now how can that be? But it's because if you're generating revenue off of a product line, you can then turn investment back into that product line and hire more people and do more work. And I have seen at companies that manage, and I've worked at 3 different companies now, I've seen it at companies that manage their intellectual property well. They have more money to invest in their research, to reinvest as their business grows, and there's an accelerating capability to move forward in terms of what you can achieve. And at companies that don't manage their intellectual property well, the marketplace becomes very splintered, and small companies have little bits and pieces of the IP, and nobody can really move forward, and things stagnate. I've seen that in 2 or 3 different ways.
Okay, thank you. Actually, as a follow-up to that question, are there any positions or titles that are allowed or disallowed to generate patents in a company?
You mean, positions or titles in terms of job titles?
Yes.
Okay. No. No, the basic answer there is no. You know, that sometimes there will be companies where, in fact, it's common now for things to be outsourced to where you have a contractor who's doing work for the company, but even in those cases, usually the contractor signs an intellectual property agreement to where ideas, technology developed under the contract become the property of the company. So really, within a corporate structure, just about anybody can apply, and you know, some people who have a track record in creating inventions will probably be taken more seriously by whoever's vetting the various patent ideas. But if it's a good idea and it stands out, it'll usually get worked on.
Thank you. A similar question for you, Dr. Williams, but not necessarily are there departments that are not allowed to generate patents, but are there departments that tend to lack the ability to patent, or do you see an overwhelming number of patents or filing for patents that are coming from one department, 2 departments versus any others?
Sure, there's tends to be a higher likelihood of patents coming out of the sciences, and that doesn't mean that you couldn't have something out of the humanities or other areas that's innovative, but there tends to be the larger research base and just more opportunity in general. But they can come from anywhere, and particularly in the business environment. I'm not an anti-software patent person, but you also have to think very carefully of how a software-based patent actually can be put into economic play. So those types of patents can actually come from many different areas of campus. But you have to really think seriously about, back to, your patent is a tool. What are you going to use that tool to do? Are you going to use it in the traditional defend, your company product line? Are you going to use it as a means to create a standard and license that out and become a licensing arm? Lots of different ways that you can take intellectual property and put it into play, but you have to think very carefully about the model and be willing to adapt as the market changes. But no, I've had grad students that have come in with tremendous industry experience already, and they could have a much bigger portfolio than a tenured professor of 10 years. It's really about what your background is, relationships, and kind of what types of problems you're working on.
Great, thank you so much. With that, I'd like to thank you both so much for answering these questions, and thank you, audience, for providing us with a host of questions. I'm sorry I couldn't get to all of them, but time was of the essence. So if the 2 of you could please just summarize, give us about maybe 3 points each from this entire discussion, I'd greatly appreciate it. I'll start with you, Mr. Harmon.
Okay, I guess the three basic points I'd want people to walk away with are that first, companies care about economic performance, and patents show that somebody thought your technology idea had economic value, so therefore they're important to companies when you go to join the company. Now, it's not because you're bringing that patent with you. It's understood that somebody else owns the patent, but it's the demonstration that you can generate patentable ideas that's of value. Second, if you have a patent or any publication really on your resume, and you go in for an interview, you want to be fully conversant with it before the interview. Make sure that you've reviewed it, because whoever you're talking to will probably want to be convinced that you actually know something about the material you had patented. And finally, you will impress the company you're interviewing if you have an idea of how the marketplace, and especially how the company you're interviewing with, can make use of your patent. So,
Thank you so much. And same to you, Dr. Williams.
Sure. So I think first, I approach it from the academic side to our researchers. Don't fear intellectual property. It's a tool. It's a social contract that's been constructed, and it's a way to help create the relationships that you want to have. So what you need to think about is not so much fixating on ownership, but thinking more about what are the opportunities that can be created, what types of control points and attribution do you need, and how does intellectual property help you do that? Second point is, imagine your work if it's scaled. You want to imagine that you're successful, not that nothing will ever happen. And if you're going to be successful, then you need to build your work on a strong foundation. And that's not just publication and all the other elements. It's also thinking about how your innovation and intellectual property is part of the dissemination and actual utilization of your work. And then third, I encourage you to work in as diverse of teams as you can, mixtures of business and law and technical and management. Get yourself into a good team where you get that mix of expertise and thinking, and that is really one of the most informative things to your innovation. Will help position your work to have valuable intellectual property rights and give you an opportunity to have impact.
Well, thank you very much, Dr. Williams. Thank you again, Mr. Harmon. I appreciate both of you for joining us for this webinar. I'd like to also thank you, the audience, for the wonderful amount of questions. Again, I apologize for not being able to get to them all. And I would like to thank the CSMC for hosting this webinar. And recordings of this webinar are available at the ventureworld.org website. This is the website for the National Collegiate Inventors and Innovators Alliance. You can also find recordings of other previous webinars that we've put together, as well as our upcoming webinars on the same website. So thank you all for attending. Thank you to our panelists again, and we hope to see you back here for the next webinar. Thank you very much. Goodbye, everyone.